Well, good afternoon. I'm Alan Sykes, along with Scott Sykes with Sykes Company, PA. We are a accounting and advisory firm that works with independent retail pharmacies all over the country. We're glad that you joined us today for this wonderful discussion that is going to be had by representatives of Brown and Fortunato PC out of Amarillo, Texas. We have Brad Howard and we have Jeffrey Baird who are going to participate with us in this process. And we're glad that you've joined us again as a part of the Master the Margin Pharmacy Influencer series that we have presented over a period of several years. And this is just another chapter in the discussion of today's topic. So with that said, Jeff and Brad, you want to take it from here?
We will do so. Hey, folks. My name is Jeff Baird, and I'm with my partner, Brad Howard, and he and I head up the healthcare group of Brown and Fortunato. We have 30 attorneys in the firm, offices in Dallas and Amarillo, and 17 of us comprise the healthcare group, and we represent a large number of pharmacies and other healthcare providers throughout the United States. We work closely with Alan and Scotty and their team, and I can tell you they're the best. I've known Alan and Scotty for years, and not only are they excellent advisors and CPAs, but they're all around good guys. And so from our standpoint, anytime Brad and I can put on a webinar with Scotty and Alan and Bonnie and their whole team, it's an honor for us. Now, Alan is going to control the slides, and Brad and I will tell him when to go to the next slide. Brad and I are going to tag team. I'm going to cover a few sets of slides. Brad will cover other sets of slides, and then we'll probably just interrupt each other and talk at times. As you have questions, type them in, and Alan and Scotty will ask us the questions, and we'll be happy to answer them. Now, let's try to put things in perspective. Tom Brokaw referred to the World War II generation as the greatest generation. There were 23 million of them. They're pretty much gone. They've been replaced by their children, and they are 78 million baby boomers. Alan and I are boomers. Brad and Scotty are not. But we have 78 million baby boomers who are retiring at the rate of 10,000 per day. Unlike earlier generations, we're going to live to be 85 years old, and our bodies are going to break down at 70, and we are going to need a whole lot of health care. And so the demand for what pharmacies have to offer will continue to go through the roof. You can't fake demand, and the demand is going to only increase. At the same time, you have your quintessential irresistible force, which is the demand for healthcare, meeting the immovable object, which means that there's only so much money to go around to pay pharmacies and hospitals and doctors and others. And so pharmacies, like other providers, are feeling the squeeze. In order to set themselves apart from the competition, pharmacies need to do a number of things. But one of which, and what Brad and I are going to talk about today, is the type of arrangements, collaborative relationships that we as a pharmacy can enter into with physicians and hospitals and others. The short answer is yes, we can do that, but as is often the case, the devil's in the details. And so we just need to make sure that as we work with referral sources, we don't cross any legal lines. Okay, Alan, let's go to the next slide. Now, as pharmacies, we're highly regulated. We live in the proverbial glass house. If we're doing something we shouldn't be doing, somebody knows about it. Because we bill federal healthcare programs, whether it's pure play Medicare, Medicaid, TRICARE, the VA, Medicare Advantage, Medicaid Managed Care, whatever, we have to deal with we have to deal with federal anti-fraud laws. The first one that you see on your screen is the anti-kickback statute. It's kind of the granddaddy of all federal statutes. It's a criminal statute. If we violate it, we go to Club Fed. And this is very broad. And what the statute says is that if I own Jeff's Pharmacy, I can't offer anything of value to a doctor or to a nurse or to an RT or a discharge planner or to a junior high football coach or to a taxi cab driver or to a potted plant in exchange for referring or arranging for the referral of the patient to Jeff's Pharmacy covered by a government healthcare, federal healthcare program. Very, very broad. You have to be aware of this. And the anti-kickback statute has only one or two exceptions, but it has a whole bunch of safe harbors, which we'll discuss here in a second. Okay, next slide, Alan. Another important federal statute is I call the Benny inducement statute. This is civil. We violate it. We don't go to Club Fed, but other terrible things can happen to us. And what this says is that I, as Jeff's Pharmacy, I cannot offer anything of value to 72-year-old Mr. Smith to encourage or induce Mr. Smith to come buy from me as opposed to going across the street and buying from Scotty's Pharmacy. I can't induce somebody to do that. However, there's an exception, and you'll see this in the third bullet in the slide in front of you. And the exception is called the nominal value exception, which says that, sure, I can offer something of value to 72-year-old Mr. Smith, so long as what I offer has a retail value of $15 or less. And if I provide multiple gifts to Mr. Smith over the next 12 months, all of these gifts in the aggregate cannot exceed $75 retail value. Next slide. Now, we've all heard of Stark. Stark is named after the former representative out of California, Pete Stark. And Stark is similar to the anti-kickback statute, except Stark is civil, not criminal. And while the anti-kickback statute applies to doctors and nurses and RTs and taxi cab drivers and potted plants, Stark pretty much only applies to doctors, dentists, chiropractors, folks like that. What Stark says is that if Dr. Jones is a big referral source to Jeff's Pharmacy, then let me back up. So let me start over. If Dr. Jones has, say, an ownership interest in Jeff's Pharmacy, or Dr. Jones or Jeff's Pharmacy is paying some money to Dr. Jones for legitimate services, then Dr. Jones cannot refer cannot refer Medicare or Medicaid patients to Jeff's Pharmacy. That's what it says. Now, Stark has no safe harbors, but it has a whole bunch of exceptions. And one of the exceptions you'll see in the third bullet is called the non-monetary cash equivalent exception. All this means is that I, as Jeff's Pharmacy, I can offer gifts. I can spend money on Dr. Jones in 2021, and I could spend up to $429 on meals and golf games and things like that. I cannot provide cash or gift cards to Dr. Jones, but if I want to take him out to dinner, things like that, that's perfectly okay up to $429. There are all kinds of other exceptions to Stark, and what's interesting is we just covered 3 statutes. Brad and I could spend 2 hours on each statute. And that's how there's so much to talk about, but we're just kind of giving you a flavor. Okay, Alan, next slide. I did mention safe harbors. There are over 20 safe harbors. There's an agency under the Department of Health and Human Services that's called the Office of Inspector General, or OIG. It's made up of a bunch of really smart attorneys, and the OIG publishes guidance. One of the things that the OIG has published are safe harbors to the federal anti-kickback statute. If an arrangement falls within a safe harbor, then as a matter of law, you're just fine. You don't have an issue under the AKS. Even if But if an arrangement does not fall within the safe harbor, it does not mean that the arrangement is bad, that it violates the AKS. It just means you have to go through more of an in-depth analysis. And so just be aware, and again, Brad and I could go for hours about the safe harbors, but just be aware of their existence. Okay, next slide. Now, I mentioned the OIG. If at night you have insomnia, you can't sleep, instead of watching Kimmel or Colbert or Fallon, pull out your iPad, go to Google, type in Office of Inspector General. Go to the website, you'll see all kinds of stuff. I'm being somewhat tongue-in-cheek, I'm also being somewhat serious. Because when you go to the website, you're going to see bulletins and fraud alerts, all kinds of publications where the OIG instructs healthcare providers on what not to do. You'll see some fraud alerts and bulletins that are specific to pharmacies, others are specific to docs, others are specific to labs, so on and so forth. And it's worth reading. In addition to that, you'll see hundreds and hundreds of advisory opinions. And what all that means is, let's just say, I'll pick on Scotty here. So let's say that
Brad, you want to kind of take it while he's locked up?
Yeah, sure. So why don't we, well, I think what Jeff was starting to say is that these advisory opinions, fraud alerts, and bulletins contain a great deal of information that update the industry. What I look for those for primarily is direction about where the OIG is going in the future. So one example is they put out a work plan every year, which is really important. That can be kind of dry reading, but it's important as a pharmacy that you either take a look at that or confer with your counsel and get a Cliff's Notes kind of summary of it. But the OIG work plan says the next year, this is what we're going to focus on. And that's important because it can include marketing, it can include physician relationships or the like. So it's really a good idea to keep abreast of those developments, not only what the OIG is focused on today, but where they're going next year. The next slide, Scotty, if you would. States, perfect. So in addition to the federal law on kickbacks and Stark law, all of the states have their own statutory schemes, their own laws. Jeff, welcome back. They have their own statutory schemes for kickbacks, fee splitting, self-referrals, and the like. So while it's important, obviously, to understand federal law for kickback and Stark law purposes, be sure, especially the pharmacies on here that have multi-state operations, be sure that you understand what the state laws are in every state where you operate. One example might be that certain state laws might say that a kickback can apply not only to government payer programs, but all programs, any dollars being exchanged for healthcare. And other states are much more narrow than that. So you want to be sure that when you practice in a specific state, besides knowing their Board of Pharmacy laws and regulations, be aware of their kickback laws and their Stark laws.
Brad,
Jeff,
quick question
Jeff,
here.
excuse me, you'll need to unmute yourself if you want to talk, Jeff.
Brad, I got a quick question here. Is there off the top of your head, any states that come to mind that are more onerous than maybe others?
Well, that's a great question. So one example is Texas. I mean, that's our home base. We practice all over the country, but in Texas, the kickback statute is extremely broad to cover all kinds of remuneration from all payers. So in years past, what a lot of pharmacies that have operations in Texas would take comfort in is that, okay, Texas has a very broad kickback statute, but the state doesn't really enforce it all that much. And that has changed. Very recently, we've become aware of some very onerous state prosecution based on the kickback statute here in Texas. So even in Texas, where that law was dormant, it's now very much alive. And That's a great question. I think it's important that every pharmacy here not only knows its own home state laws, but if you have any contracts, you have licenses in other states, you do business in other states, the regulators will assume that you know all those states' laws as well.
All right,
Brad,
Jeff, you're
can you
still
hear me
muted.
now?
Yes, we can.
You can hear me now?
Yeah.
Yes.
Did I go offline there for a little bit, Brad,
Mm-hmm.
earlier? Sorry about that. I love technology. Okay. But going back to the states, you know, particularly with compounding pharmacies that are cash only. You know, if we're a cash only pharmacy, we don't really have to worry about the federal laws, but we have to look at the state laws. And as Brad mentioned, every state has an anti-kickback statute. Some are really broad, such as Texas. Florida's a nightmare. California's broad, so is Ohio. Others are quite narrow, such as New Jersey. And so you have to just be aware as to what the state anti-kickback statute is. In addition to that, every state has its own pharmacy code, CODE. These are pharmacy laws that are specific to, these are laws specific to pharmacies. And so we just need to be aware of those as well. Lastly, I think before I went offline, I was talking about advisory opinions, and all that means is that if you as a pharmacy want to do a deal with a local hospital or with a local lab or somebody, and you're just not sure, you're kind of concerned that it might violate the AKS, you can submit a request to the Office of Inspector General and say, hey, we want to do this, what do you think? And then the OIG will publish an opinion, and you can see this on the website we were talking about, where the OIG will redact your name, so it'll be party A, party B, but the OIG will then discuss the facts and then say one of three things: either, hey, it looks fine, or don't do it, or, well, we don't particularly like it, but we don't think we'd bring enforcement action. So just kind of be aware that as pharmacies, you know, we have to be aware of the federal laws, of the state laws, but there's all kinds of guidance out there. Okay, Alden, next slide, and I think
Jeff, we got a question here. Where does STARK or anti-kickback apply to cash-only transactions like non-insurance claims?
Good question. Okay. The short answer is they don't. Okay, the short answer, Alan and Scotty and Brad, is that if a pharmacy is only dealing with cash items, then we don't have to worry about the federal laws. We only have to be aware of the state laws. Where it gets complicated, however, is this, and I could talk until your eyes glaze over, but let's just say that Dr. Jones is a referral source, and now let me give you a better example. We've got John Smith is going to be our marketing rep. He's a 1099. He's going to go out and knock on doctors' doors and knock on hospitals' doors. He's going to bring us two buckets of patients. Mr. Smith is going to bring us some patients covered by Part D, which is federal, and going to bring us patients that are strictly cash. I, as a pharmacy, I would love to pay Mr. Smith for a commission for the cash patients and pay him nothing for the Part D patients. Well, can't do that. That's a prohibited carve out. And so the short answer is, if we're just dealing strictly with cash, we don't have to worry about these federal laws. If, however, we're dealing with a combination of cash and federal, then we do have to take into consideration the federal laws. Okay?
One thing I might add there, I think that's a good answer. One thing I would add also is that there is, under the federal law, a general healthcare fraud statute.
Good idea.
It's a criminal statute, and that's got very broad applicability. So if you're truly a cash-only pharmacy, that's all you do, all day, all night, and that's it, I would still be sure that any marketing arrangements, like Jeff mentioned, and the like that bring you business, I would still vet those with your legal counsel because you can still fall under the other federal laws that aren't kickback or stark, but general healthcare fraud, which we've seen over the last few years are extremely broadly interpreted by prosecutors around the country. So at least get a legal opinion before you decide that you want to get very aggressive in your marketing, even if you're cash only.
Okay, let's go back to the previous slide. There you go, Brad. I think this one's yours.
Yeah, I'm going to go ahead and cover this maybe for 3 or 4 minutes because this is a hot topic at all times for pharmacies, but especially in the last 2 years with the enforcement environment, and that is a pharmacy's use of employees versus contractors to market the pharmacy. And I'm going to focus on a couple of things here that we see commonly, and that is sales representatives, whether they should be employees or 1099s, but then also marketing efforts generally by outside providers. And those are the 2 topics of marketing that I've seen the most in the investigations world the last couple or 3 years. As a very general sense, it's a violation of the kickback statute for you as a pharmacy to pay production-based compensation, meaning a percentage of sales or receivables, to a 1099 independent contracting rep that generates federal dollars or patients for that provider. Now, we'll also add there that under a number of these state kickback laws, it isn't limited to federal programs. It can also be any payers. So it's a violation generally to pay production comp to a 1099 independent contractor. I would say whatever state you operate in, however many states you operate in, you got to keep that at heart whenever you're making decisions about how you pay people. If you're going to go 1099, it shouldn't be with an individual. It should only be with the company, but that arrangement's got to be vetted by healthcare counsel because there are a lot of ways to foul that up. So that's a very general admonition to be very wary of 1099 relationships if you're marketing for your pharmacy and to focus a lot more on W-2 employees. The OIG is the one around the country that's expressed concern about these arrangements, and they're the ones that will review not only your outside marketing companies, if you have one of those, but even the inside people that work for your pharmacy to vet whether they're truly W-2 employees or 1099. And I'm going to say something here that I've seen all too often in the pharmacy world, and that is where a pharmacy has a contract with somebody that they call a W-2 employee, but they treat them like an independent contractor, like a 1099. Here are a couple of examples. That would be where you've got sales reps that you pay as employees, but they don't fall under any of the company's policies. They don't fall under the handbook. They don't receive any training, and they're paid in large part or maybe completely on a commission basis. And they're called W-2, but they're really treated like independent contractors because they can do that same work for other pharmacies besides yours, which most employees can't do that. So if you've got somebody that is out there getting business for your pharmacy, you can call them an employee, but the more important thing is you've got to treat them as an employee. And the main thing that the government focuses on there is how well do you supervise them? So how well do you supervise their script when they go see physicians who refer business to you? How do they account for their time and their expenses to you? Do you treat them just like you would any other manager or pharmacist within the business? So that's a really important thing to do. What I've seen a lot in the enforcement world in the last couple of years is when a pharmacy is under investigation by maybe a state agency, an attorney general's office, or in some of the more severe cases, the Department of Justice, one of the first things that the government asks for is provide us everything that shows how you pay people that bring sales to your pharmacy, whether you call them independent contractors or you call them employees. We want to see all those agreements. If you don't have an agreement, we want to understand how it is that you're paying those folks. So I would be sure here in your spring cleaning to vet relationships in your pharmacy and be sure the government would see all those people as actual employees. Another thing that I've seen recently in the enforcement world is scrutiny of relationships that your pharmacy has with outside marketing groups. So a lot of those contracts will say that the marketing group is going to do online advertising for your pharmacy, maybe some radio and TV ads, print media. They're gonna increase your profile out there in the internet, because all of us operate out there now, to bring you more business. the first thing we always advise clients if they want to enter into a relationship like that is to be sure it's in writing, and that relationship is going to endure for at least a year, and that you're not paying that company a percentage of sales or commissions. One thing I'm working on right now that just popped up for a pharmacy is where they had a relationship like that with a marketing group that was doing all those things I just mentioned, and the contract even had all the right language, but the reality was the pharmacy was still assessing that number and cutting the marketing group in on a percentage of sales, even though the contract said they don't do that. And that's going to be an issue in the matter that I'm working on now. So it's really important, however you bring business into your pharmacy, to ensure that you're using employees, or if you use outside marketers, to have an agreement in writing for more than a year at fair market value that isn't based on the amount of business they send you, and even then have that vetted by your healthcare counsel to be sure it's good to go. One last tip on employees that I've seen a lot here in the last couple of years, Jeff and I have a lot of clients that have encountered this issue, is where you've got employees that are truly W-2 employees, and then you find yourself under some kind of an investigation, and the government asks for all the documents and agreements you have in that regard. I think it's important, no matter where your pharmacy is located, that your sales representatives, if you have them, they should have employment agreements in writing and should set out very specifically what their duties are, but also what your controls are. So not a one size fits all. These need to be tailored to your individual sales representatives. Another thing is, I would certainly advise you to not pay your sales reps pure commission. That looks a lot more like something the government's a little concerned about in the kickback world. When we write those agreements, we typically will advise the pharmacy to have a larger base salary. It's fine to have a commission aspect to ensure that there's an adequate base salary there. And then with regard to the commissions, ensure that they're fair market value. I've got one I worked on before where the sales rep was making $1 million a year. Government's concern was, what sales representative really makes $1 million a year? That sounds like some other kind of an arrangement, and they vetted it very carefully. So with regard to your W-2 employees, ensure you control them and ensure they're actually employees subject to your supervision. On the next slide, if you wouldn't mind.
I think I've got this with Brad.
Yeah, go ahead, please.
Now, three things I want to touch on that what Brad said. They're not in the slides. As a pharmacy, if a lead generation company approaches you and wants to sell you leads, your first reaction needs to be to run for the hills. Now, then your second reaction needs to be pick up the phone and call a healthcare attorney and get advice. Most of those arrangements are really precarious and can get you into trouble. So just be really careful in terms of working with a lead generation company. Number two, if a telehealth company calls you and says, hey, let's work together, again, your first reaction, run for the hills. After that, call a healthcare attorney, because there are a lot of sham telehealth arrangements that are out there. Number three, Brad mentioned the questionnaire or the questions asked by state AG's offices or by federal agencies on tell us how you market. Well, in the Master the Margin series, Brad and I have the honor we're going to be putting on 3 programs for Olin and Scotty. And the third one is going to be working with PBMs. Mm-hmm. And when it comes to re-enrollment with PBMs, they routinely ask, how are you marketing? Mm-hmm. And if it looks like we're out marketing through 1099s, then that might very well give the PBM grounds to terminate the contract.
Yeah, can I add one thing there, Jeff, for just a second? And that's a great point. So for a client recently, they received from Express Scripts an audit, and then the audit didn't go very well for them because they couldn't demonstrate where they bought all their product adequately, at least to ESI's satisfaction. Then that gravitated over to what we call a fraud, waste, and abuse investigation, and those are much more common now than they were even 2 years ago. I mean, virtually every pharmacy at some point in time has the misfortune of being involved in a fraud, waste, and abuse investigation by a PBM. One of the very first questions they asked that pharmacy as a part of a questionnaire during this investigation was, do you have any contracts with any company that helps to generate business for your pharmacy? If so, please provide copies of those contracts now. So in 2021, here in April, the PBMs are asking for evidence of any of those relationships if you're under scrutiny. So to Jeff's point, be very careful, ensure those have been vetted.
Now, assume that Dr. Jones is a big referral source to Jeff's Pharmacy. And let's say that Dr. Jones is part of a 5-physician group. What can I do to wine and dine Dr. Jones? As you'll see in the slide in front of you, under Stark, I can spend up to $429 in 2021 to wine and dine Dr. Jones. That amount's going to go up somewhat in 2022 and 2023 and so on and so forth. Now, we can, what I do for Dr. Jones, golf, meals, take him to a concert or something, cannot be cash or cash equivalent. Now, if Dr. Jones is part of a 5-physician group, then that's $429 for each of those 5 physicians. Now, what's interesting is that there is not a similar exception or safe harbor to the AKS, meaning that technically, if I, as Jeff's Pharmacy, I go spend, let's say, $415 on Dr. Jones in 2021, I'm just fine under Stark, but technically I'm still violating the anti-kickback statute. From a practical standpoint, not a problem. If we fall within the Stark exception, we're going to be just fine under the AKS. Okay, next slide, Alan. Now, as Jeff's Pharmacy, as I'm wining and dining and doing things with Dr. Jones, I also need to, not only do I need to comply with Stark, but let's make sure we're good under state law. As I mentioned before, we have what's called every state has a pharmacy code, CODE, which are a whole bunch of statutes and regulations pertaining to pharmacies. Let's see if there's anything in there that restricts what we can do with the doctor. And then likewise, every state has what's called a Medical Practice Act, or MPA, that are specific to physicians. And let's see if there's anything in there that might prohibit or restrict the type of gifts and things I can do for Dr. Jones. Okay, next slide. Now, I think that in addition to what we call wining and dining, it is perfectly legitimate for Jeff's Pharmacy to pay Dr. Jones, who's a referral source, for legitimate services. Now, it's Brad and I can tell you that in fraud and abuse land, it's the duck test. If it looks like a duck, sounds like a duck, walks like a duck, it's a duck. Or to quote the old Charles Schwab commercial, Scotty, who's much younger than his father, won't understand this, but his dad will, which is the old Charles Schwab commercial, which is you can put lipstick on a pig all you want, and it's still a pig. Okay, so those are good guiding lights, guiding principles when it comes to fraud and abuse. So anyhow, the point I'm trying to make is if we're going to pay Dr. Jones, then let's make sure it passes the duck test. He's got to provide legitimate services, and then the money we pay is going to be fair market value, for example. And Brad will cover this more later, but if Dr. Jones is going to be my medical director, that's fine. But let's just make sure that he provides legitimate services and the money we pay him is fair market value. Okay, next slide.
Hey, Jeff, just for a second, if you don't mind, one last thing I might mention on the slide about the $423 that you can spend per physician per year for some of these items. You want to track those items closely.
Smart.
With receipts. You want to have a file. What we recommend, if you have a pharmacy and you've got, to Jeff's point, you've got 5 doctors in a group that refer a lot of business to your pharmacy. Well, obviously they do that because you're you're very good at what you do. Your customer service is top notch. You take care of their patients. That's why they send you the business. But if you also wine and dine them on occasion, or send over the Jason's Deli for lunch for their staff, or send over donuts and coffee, or whatever you do to keep the relationship warm at all times, be sure you track that very closely in your records with receipts, because if you do find yourself under scrutiny, you want to just pull out the file that says, here are the receipts that demonstrate last year I spent $310 on the first doctor and this much on number 2, 3, 4, and 5, and you'll be fine.
In fact, before you go to this next section, Brad, let me follow up. This $429 in 2021 for Dr. Jones does not apply to his staff. Why? Because Stark does not apply to non-physicians. And so the question becomes, if I, as Jeff's Pharmacy, if I drop off once a year a box of Krispy Kremes to Dr. Jones's staff, I guess technically I could argue that's a violation of the anti-kickback statute, because I just dropped off a $4 box of donuts. And Dr. Jones's staff is just as much of a referral source as Dr. Jones himself.
Mm-hmm.
Having said that, who cares? They're donuts. And so now we go back to the duck test, and that is, nobody's going to care if we drop off Krispy Kremes once a year, twice a year, once a quarter, once every 2 months, or even once a month. They're donuts, for gosh sake. Who cares? Where you start getting into trouble is when you're dropping off Krispy Kremes every week or every other day or something like that. Then it starts to become a little bit over the line. Likewise with Dr. Jones's staff. Can we treat Dr. Jones's staff to Jason's Deli once a year? Sure. Twice a year? Yeah. What about once a quarter? Perhaps. Can we treat Dr. Jones's staff to Jason's Deli once every 2 months? What about once a month? What about every week? No. You get to a point where it starts feeling uncomfortable. And so just be aware that that you just need to have certain limitations when it comes to how we are marketing to the physician staff. Okay, Brad, I think this one's fun, because this is the one where you jump into incest.
Yeah, this is, so the next topic here for just a couple of minutes is whether you can pay a doctor that refers business to your pharmacy to provide an education program. And there are very legitimate ways to do that, and then some that are certainly more illegitimate. The key requirements are that the program this doctor is going to present needs to be substantive and valuable to the audience. It needs to be something that's relevant, cutting edge. You can talk about, for example, in 2021, findings from COVID, the debrief from what we all experienced for the last year might be a very relevant topic, and how you might treat patients that have COVID-related conditions or after effects of COVID or the like. And so that's a very relevant topic. If instead you pay the doctor to present the same old program every 6 months, and it's really more of a dinner, social get-together, that looks much more problematic. So there has to be value in the program. The next thing is, when you pay the doctor to do this, to be here for this program and this presentation, it's got to be obviously fair market value that reflects the time the doctor has spent for the program to prepare it and to present it. So one thing I saw in an investigation recently that was concerning was pharmacy pays physician a flat fee, a certain amount of money to do a program, $2,500. Well, the program took an hour. So at that point, it's a $2,500 per hour fee, which no prosecutor is going to believe is fair market value. If, however, the pharmacy pays the physician $2,500, but that reflects his regular hourly rate, including 5 or 6 hours of preparation for the presentation, and in fact, there are PowerPoints, there's slides, there's real content there that's been documented that can demonstrate this is how much time the physician spent, then that can be, in many cases, acceptable, and that'll pass scrutiny. There was a case recently called the Incest case that was decided. It's a criminal case where the DOJ looked at these speaker programs and they found one that they believe was fraudulent. In that case, these programs really didn't involve just the pharmacy staff. The pharmacy staff invited a lot of their friends. So it was a big get together. There were a lot of dinners where you could bring your spouse, you could bring other friends. These were at very high-end restaurants. The programs presented by the physicians were not cutting edge. They weren't terribly relevant. In fact, it was kind of the same program over and over again, which the DOJ said was problematic because it looked like the pharmacy was just paying, the company was just paying the doctor for referrals, rewarding the doctor and his staff and his friends and family for referrals. So a couple of takeaways from that. That is, it reiterates the point there that you want a real substantive program that you can pull it out. If you're ever reviewed by the government, you can pull out the folder and say, here's the program that was presented. Here are the questions that were asked of the audience. Here are the audience participation exercises. This is what this hour or 2 hours was all about. It wasn't about the dinner or the drinks. And then to that point, the DOJ takes a very, very dim view, and NSYS was a good example of these speaker education programs where alcohol is served. So although it sounds pretty prude and conservative, the first thing I'll tell a client is if you're going to put on one of these programs, you really shouldn't serve alcohol. If you're going to serve alcohol, you're going to disregard my advice. It can't be Odette wine for $250 a bottle. It can't just be top shelf liquor, open bar, help yourself. There's got to be control there. It's got to be about the program, not about the fun. So it might be that you have, I'm not saying this will pass scrutiny, but if you have a limitation, you can have a drink or you can have 2 drinks. After that, you've got to pay for your own alcohol. Or if you provide the dinner, but say, we need you to pay for your own alcohol, something like that, that looks a lot less interesting to an investigator than a big Friday night event that's called a educational event. So that case is very telling. And what it says to me and to Jeff as healthcare lawyers is, if you're going to have doctors put on programs for your staff, be sure that education is the #1 goal, and then be sure that you pay the doctor only for time spent doing it. And last, ensure that the optics aren't bad. To Jeff's pig point, be sure the optics are good. You put it on in a regular place, not the highest end restaurant in town. It's about the event, the education, not about the dinner, the drinks, and the fun.
And Brad, I would add a fourth there. It sounds like document.
Absolutely, very good point. Document the substance of the program and what people learned. You could even have questionnaires at the end. You know, what was most beneficial to you? What can we focus on in the next program to provide additional value to you? Something that demonstrates that it was really about education.
Good. Okay, Alan, there we go. Now, out there, there's a phenomenon called frequent flyers. And these are Medicare patients who are admitted to the hospital for a particular type of disease, such as congestive heart failure or COPD. And the patient stays in the hospital, Medicare pays a whole bunch of money, patient is discharged, and then 14 days later, he's readmitted for the same problem. Well, that is covered by what's called the Hospital Readmissions Reduction Program. And that is, let's just use the fictional St. Mary's Hospital. If St. Mary's has these frequent flyers that keep coming back in, then Medicare is going to penalize St. Mary's. Medicare is going to say, you know, you're not doing a good job of healing your patients before you discharge them. You're not doing a good job of following up with the patients after they're discharged. Because they're being readmitted for the same disease in less than 30 days, you're unnecessarily costing us, the Medicare program, a whole bunch of money. Therefore, St. Mary's in 2022, we're going to reduce what we're going to pay you. And so this has put the responsibility on hospitals to, I call it a touch, T-O-U-C-H, where when the Medicare Benny is discharged, let's say the beneficiary is a COPD patient, is discharged, where the hospital wants to do what is necessary to keep that patient healthy so that the patient's not readmitted, because I mean, the hospital does not want to be penalized the following year. Well, that's where a pharmacy can come in. we're seeing this more and more with pharmacies and DME companies and home health agencies, where Just Pharmacy can approach St. Mary's and say, when you discharge patients, we would suggest that you refer the patients to us, Just Pharmacy, and we will work closely with the patient's doctor and caregivers caregiver to keep the patient healthy so that he or she's not readmitted anytime soon. For example, I, as Just Pharmacy, I may coordinate with the doctor to make sure that the doctor is having visits, whether it's via Zoom or in person, with the patient. I might coordinate with the adult child who's the caregiver and say to the adult child, is your mother or your father taking the medications as prescribed? Is your mother or father going and actually seeing the doctor? Is your mother and father hydrating? Basic things to keep the patient healthy. This is the type of collaborative arrangement that a pharmacy or a DME company, for that matter, or a home health agency can offer to a hospital. Okay, next slide. This is kind of a big deal. I mentioned at the beginning 78 million baby boomers. You know, back in 1965, when the Medicare law was passed, your average male factory worker in Detroit would work till he's 65, retire, die at 66. Well, that was then. This is now. Alan and I are roughly the same age. We're both boomers. We're going to live forever. But sooner or later, age is going to catch up to us, and nobody can dodge that bullet. Well, you know, when it does, then the millennials out there, you know, Scotty and his generation has got to support us. What this means is that what I call the long-term care industry is going to continue to grow, whether it's pure play nursing homes, whether it's skilled nursing facilities or SNFs, whether it's assisted living facilities, or some type of a combination thereof. Well, let's talk about any type of long-term care facility. In order for a long-term care facility, particularly a custodial care facility, or SNF or whomever, to get paid by Medicare, then the facility needs to implement what's called a DRR, which is a drug regimen review. Okay, next slide, Ellen. Now, to do this, the facility needs to have a pharmacist once a month come in and look at what drugs are being given to patients. And the pharmacist is to try to figure out if there are going to be any adverse interactions among the drugs. It's the pharmacist's job to try to be a problem shooter. Now that costs money to do that. It means the long-term care facility needs to pay the pharmacist money to come and do that. Now, it's not required by law that the long-term care facility have what's called EMAR, the electronic medication administrative records. It can be blue ink, it can be hard copy, but that's really unwieldy. And so what has happened is the government has recognized that there is a need for a pharmacy. I guess it could be any other provider for that nature, but there's a need for a pharmacy to offer or to donate software, electronic medication administrative record software, to a long-term care facility to try to bring the facility into the 21st century, because that's good for everybody. It's win-win-win-win all the way around. Unfortunately, that can also violate the federal anti-kickback statute. Why? Because if I, as Just Pharmacy, if I donate a $7,000 software package to St. Mary's nursing home, then I am now giving something of value to a referral source, hence we have a kickback. Well, so there's this conundrum. Okay, next slide. So the Office of Inspector General published a safe harbor called the EHR Safe Harbor. And there are also a few advisory opinions that deal with this. But the bottom line is that the OIG has said, Jess Pharmacy, you can donate the $7,000 software package, EHR, to St. Mary's long-term care facility if 12 requirements are met, and they're all laid out in the safe harbor. One of the requirements is that the St. Mary's has got to pony up 15% of the cost of that particular software. So this is kind of a balancing act, juggling act between the need to bring nursing homes into the technology age, at the same time trying to prevent unnecessary kickbacks. Now it's kind of interesting, and Brad, actually the next webinar that Brad and I give for in the Master the Margin series, we'll be talking about giving value-added services to patients and not violating any of the federal laws. Scotty and I were talking at the beginning of the webinar before you all came on, the fact that back in November, CMS modified Stark and the OIG modified the anti-kickback statute to relax them, make them not quite so prohibitive, not so intrusive, so that we as pharmacies can provide additional services to our patients. And we'll cover that during the next webinar.
And Brad, we've just got about 5 minutes left. We've got a few questions that I wanted to cover here.
Sure.
One being from Emily, would there be any conflicts in allowing a prescriber to operate a telehealth operation out of an additional space in a pharmacy without charging them or having a contract? Number one.
Okay.
They would not be receiving any fees, and this would be done purely as a way to increase access to care in the community.
That's a good question. My gut reaction is no. You got to charge the pharmacy. You got to charge the doc, because if and that's a great question, by the way. But if Dr. Jones is a referral source to the pharmacy, and we are providing this space, this resource to the doctor, then that is something of value to a referral source. Let me think for a second now. Yeah, I don't think there's any way around the pharmacy needing to charge the doctor fair market value rent for the space. I'm trying to think of the modifications or relaxations to Stark and the AKS that have come out since November, but I don't see any of them. I don't see any of those that would eliminate the obligation of the doctor to pay rent. Certainly it could be on the low end of fair market value, but nevertheless needs to be fair market value. Brad, do you agree or not?
I do. I would have that vetted very, very carefully, because I think that enforcement agencies would not see it. I understand the promotion, the access to healthcare. That's very laudable and a good reason to do these arrangements. That being said, I don't think the regulators would take that view of it. So at a minimum, I'd have it very carefully vetted by your healthcare counsel. That makes me kind of nervous just initially hearing about it.
And one last question here. What about, can a pharmacy under a business agreement charge a provider for providing a legitimate purpose for fair market value?
Yes.
Okay.
Bottom line is, that's kind of a general question, but as a general rule, if we have if somebody's providing something of value to us, let's say, we need to pay for it, and need fair market value. And that is okay, even if who we're dealing with is a referral source. I think that the takeaway, all in Scotty and Brad, is that, if we are paying fair market value for legitimate services, then that cures all ills.
And to Scotty's point earlier, one thing I'll add there is, I know we're closing out, and that would be the documentation is the key there. So if you're paying fair market value and you really believe that, you should be able to demonstrate that with ease So be sure you've got your file set aside electronically or otherwise that demonstrates why you're paying for that. If you have any nerves about it at all, get some comps for the same service from somebody else. Have that in your file so you can demonstrate you're paying fair market value and not anything more.
Well, gentlemen, on the screen, I have your contact information, and I can tell you that both Brad and Jeff are experts in their particular area of healthcare law and employment law, and our firm uses them tremendously in the processes of working with independent pharmacies all over the country. We also have our contact information here on the screen, and this is, again, the first of a series of several seminars we will be doing under the Master of the Margin process with Brandon Fortunato. I believe the next one is in the next couple of weeks, and you probably will be receiving an email about this. And if you register for this, you'll be getting a link where you can replay the recording. It'll also be posted to our website at sykes-cpa.com. And gentlemen, we appreciate you being on the call today, and we appreciate all of our attendees appearing today. And we look forward to the next call. Thank you
Thanks
very much.
Thanks, everybody.
Have a great day. Take care.
You know.
Bye.